Okay, Madam Chair, we are on public session.
Thank you very much. Good morning, everyone. Welcome to the meeting of the Joint Commission on Public Ethics. The meeting is now called to order. As with all JCOPE meetings being held during the pandemic, we are using video conferencing technology. The public session of this meeting is accessible on JCOPE's website to watch via live stream. A couple of important reminders. It is important that only one person speak at a time. In addition, I ask that when you speak, you identify yourself so that we have a clear record. As has been our practice, we will take votes via a modified roll call to ensure that everyone is counted. Please also remember to mute your phone when you are not speaking. Deputy General Counsel Levine, can you please confirm that we have a quorum? I think all commissioners are present on the call. Is that correct?
Yes, ma'am. All 14 are here.
Thank you. The second item on the agenda is the approval of the meeting minutes of the commission. Behind attachment A are the minutes of the public session of the March 23rd, 2021 meeting. Are there any corrections to the minutes? Okay, I don't see any hands. Behind attachment B are the minutes of the public session of the April 9th, 2021 meeting of the commission. Are there any corrections? Okay, I don't see any hands. Can I please have a motion to adopt both the March 23rd and April 9th minutes of the public session of the commission?
I see Commissioner Weissman.
I saw Judge Braun. Judge Braun, is that a second? Thank you. All in favor, please raise your hands.
Okay, I see Chair Varlak, Commissioners Fisher, Weissman, and Deering, Horowitz, McNamara, Yates, Newton, Braun. Commissioner Cullen?
Yes.
Commissioner Jacob?
Yes.
Commissioner Levine?
Yes.
Judge McCarthy?
Yes.
Motion carries, ma'am.
Thank you. Let's move on to item 3 on the agenda, report from staff. General Counsel Stan.
Hi. We'll start with the operations update. The monthly operations report is behind tab C. If anyone has any questions, I'm happy to address them. Otherwise, I will turn it over to Director of Administration, Steve Boland, to do the end of year financial report.
Good morning, everybody. This is Steve Boland. I want to go over the annual report for 2020-21. The year-to-date cash disbursements for personal services ended up being almost $4.38 million. And for non-personal service, it was almost $587,000 for a year-to-date total of $4,915,000. And we achieved our cash goals from the division of the budget. We spent 88.9% of our budget. Does anyone have any questions? Thank you.
Okay.
This meeting is being recorded.
Apologies, we're all set.
With that being said, I'll just inform the commission that we received our budget appropriation, which was $5.594 million. It's basically the same as in past years, but we got a small increase of $12,000 in our non-personal spending, services spending, which is to accommodate the prospective lease in Buffalo when we have to move out of the state office building into a private building. And I think that's expected for this fall. Otherwise, the numbers are very similar to prior years. Does anyone have any questions? Okay, then with respect to finance,
Commissioner Jacob here. Monica?
Yes.
What is the status of our downtown New York office?
So the New York City office was temporarily relocated within 25 Beaver Street to a temporary space, and it is functional. We are all continuing to work from home for the most part for now. but when we are all ready to return to the office is functional. And then we will be moving into our permanent space, sometime hopefully this fall. That's when the construction on our permanent space is supposed to be done, also on 25 Beaver Street. We haven't had an update on where they are with the construction, but I can get one for the next meeting. But with a temporary space, will accommodate all staff and commission meetings and trainings if needed.
Thank you.
So the other issue, I just wanted to remind everyone who is subject to the financial disclosure statement requirement that filings are due. People should have received their notices by email. You can file electronically, or you can file a paper version. The filings are due by on May 17th, Monday, May 17th this year, because May 15th falls on a Saturday. If you haven't received your notice, you should reach out to your ethics officer or JCOPE to let you know. Commissioners, you should have all received a copy of a filing in with your packages. If you file electronically, you have the option of pre-filling your filing with last year's information to make it easier, and there's staff available to answer any questions. Okay, with that being said, I'm done with the staff report.
Thank you very much. Does anyone have any questions on any of the items that were reported by staff? Okay. So moving on to item 4. Item 4 relates to the delegation of authority to staff. It is behind your Exhibit D. The current proposed draft resolution is found behind Exhibit D. While we've discussed this previously, General Counsel Stam, can you provide just a high-level summary of what the resolution proposes to do?
Sure. And so this is an amendment to one portion of the existing delegation, and what it purports to do. And please, commissioners who worked on this, correct me if I say this inaccurately, but with respect to certain types of guidance, which we're calling for purposes of ease, approvals that are required under the agency's regulations, such as outside activities, expense or service payments, honoraria. Those approvals for statewide elected officials and agency and department heads will be approved by the commission going forward. In addition, it just formalizes some of the other practices of the agency with respect to informal guidance issued by staff, and that the effect of those opinions that will be in place, but the commission can reconsider any staff opinion, but any changes that the commission makes to a staff opinion will be prospective only and will not affect the requester. And it makes clear that the commission can publish even informal letter opinions in a redacted form. I think that covers it. In addition, that staff will provide to the commission at each meeting a list of all letter opinions that have been requested and have been issued.
Thank you, General Counsel Stam. To all the commissioners that worked on this particular resolution, is there any additional comment or any clarification that anyone wants to make with respect to what General Counsel Stam has indicated?
I have one, Chair.
Please.
Chair Ball, this is Commissioner Jacob. I actually have no problem with what is in paragraph 2, the notion that a recipient of such an opinion can present it in defense, and that is permissive. I suppose we can bar such a presentation, but what we are saying, it may be presented. I would offer an amendment that gives more comfort to the recipient of an opinion. One that says that if you have not omitted, you have fairly stated the facts, and you've not omitted any material facts, the recipient should enjoy the knowledge that the staff, that if the recipient acts in accordance with the opinion, that staff would not in the future seek or recommend enforcement action against the recipient to the commission. This is similar to what is done on the federal level with SEC no action letters, where if staff advises a requestor for advice and that person acts in accordance with the advice, that staff assures the recipient that it will not recommend action against the recipient if all of the facts were fairly stated in the letter. So I would urge that my colleagues consider adding to paragraph 2 that the recipient understand that if the letter opinion has all of the facts, all of the material facts, and the recipient acts in accordance with the advice, that staff will not recommend enforcement action to the commission. That doesn't mean that we as a commission are barred. If on our own, we decide that we should take enforcement action, that would hardly ever happen. I'm not aware of it ever happening on the federal level. But I'm seeking an amendment to paragraph 2 that leaves paragraph 2 as is, but adds the provision I'm talking about.
Okay, so before we can seek to have an amendment, and please correct me if I'm wrong with respect to my parliamentary procedure, do we need to have a motion and a second on the resolution? That's my understanding, and then at that time there can be. I see my Judge Braun is agreeing with me. Okay. So,
Yes, that is true. That's true.
Okay.
Okay.
Thank you.
To the chair, I would move this. I don't want to reiterate everything. We've talked about this for 4 meetings in a row. So I think everyone understands it, and enough is enough. It's a compromise that, and I thank Commissioner Fisher for all the work he did in taking the original motion that I had back in November or so, which failed on a 6-6 vote. And I think with his improvements on it, maybe today we can do better than 6-6. So I thank him and I'll move it.
Thank you. Is there a second? Yep, I see it.
Excuse me. On the motion?
We don't have a second as yet. Hold on, I want to make sure. Okay, so we've got a second. Is there any discussion?
Clarification, please.
Yeah, I'm sorry.
Hello? I'd like to ask whether Judge Yates is moving the resolution with or without the amendment I have proposed.
So I
will move the amendment.
Sure. So let me just clarify. I asked for a motion to move the resolution that is in the book. So now that has been moved, you can move to amend.
Oh, okay.
Okay.
Well, I moved. Then I can do that now.
You can. Yes.
I think what it would be is that Commissioner Jacob would suggest an amendment, and then Commissioner Yates could consider accepting that. Is that correct? Yes, Judge Braun, our parliamentarian, is shaking his head.
Yeah.
So it's not a separate motion. Would Judge Yates accept an amendment to his motion, and then we'll proceed from there.
A friendly amendment.
Okay.
That's my question.
All right. Here's my feeling about it. I do think in nature it's consonant with the original motion, and merely adding in some words that say that a person who honestly relies upon a letter of opinion, an informal letter of opinion, will not face in the future a staff recommendation for discipline. I think that's okay. We don't have the exact language, and my position is this. I would like to have a vote today on the main motion. So I wouldn't like the amendment to either delay this for people to see language, and I think we should have a separate vote on the amendment, because if there's not a sufficient number for Commissioner Jacobs' language, I don't want that to be a reason for the main motion to fail.
Thank you, Judge Yates. Commissioner Horowitz?
Thank you, Madam Chairman. I appreciate the work, particularly that done by Commissioner Fisher on Commissioner Yates's original proposal. I don't love it, but I'm prepared to support it. However, to Commissioner Yates's point, I will not support Commissioner Jacobs' friendly amendment. I believe it undoes it. It will undo safe harbor. It'll have a chilling effect, and it will render the staff's advisory work to people soliciting the staff's view meaningless. So to Commissioner Yates's point, if this amendment is agreed to, I won't support the motion. If we put it off, I'd be happy to support it. Thank you, Madam Chairman.
Thank you. Commissioner Braun, Judge Braun?
To Commissioner Yates, I'm offering what I would hope and presume would be a friendly amendment. It's merely housekeeping. In the last whereas clause, it refers to Chair Michael Rosen. As we all know, we have a new esteemed, capable chair, Commissioner Varlock, and either it should say, I think the better way to say would just say, along with the chair, and remove Michael Rosen. I just want to also say for the record, the same whereas clause says, in the absence of an executive director, the implication is, and I think it can remain as is, that once we have an executive director, then that paragraph, that whereas paragraph goes out of effect as long as we have an executive director. And just on that point, but not to speak to it now much, I would hope that either at this meeting, preferably in our executive session, so as not to invade the privacy or embarrass anybody in discussion who's applied for executive director, but I would hope that after over 2 years, we would today, or if not today, very, very soon, take another vote and approve an executive director and hire such person. But in any event, back to you, Jim. The only change I propose is take out Michael Rosen and change it to read along with the chair.
So Judge Braun, yes, General Counsel Stan.
Judge Braun, I just wanted to clarify that, and there's another way you could do this, but this particular whereas clause is a past tense. So it's talking about what happened in June of 2019. So to effectuate what you want, we would have to rewrite it further. It's not a forward-looking paragraph. There was a forward-looking paragraph that was edited out, I think, between the negotiations between Commissioners Fisher and Yates, but this paragraph is a historical paragraph.
Yeah,
yes. Let me speak to it, Jim. I do see that now in terms of the grammar, so it can remain as is.
Okay.
I will withdraw my proposed amendment.
Thank you, Commissioner Braun. So we've got one commissioner who has thus far indicated that they are prepared to move forward, but are not accepting the friendly amendment offered by Commissioner Jacob. Judge Yates, what is your pleasure?
As I said, I'd like to have a separate vote on both. Now, maybe sequentially, the way to do it is move the bill or move the resolution as printed and agreed to by Commissioner Fisher and I, get a vote on that, and then take a vote on Commissioner Jacobs' amendment, which I'd be fine doing it that way, but I don't want to amend the main motion right now as a friendly amendment.
Okay, thank you, Commissioner Yates. Judge Yates, are there any,
Ma'am,
I'm
Just-
sorry?
you have a motion on the table from Commissioner Jacob. It was a friendly amendment, and it appears it was rejected by the author of the original motion. So the discussion is still open. If Commissioner Jacob would like to move his amendment, now is the appropriate time to do so. And if that advances, then we would consider the main motion. But the discussion on the motion is still open, so this would be the appropriate time.
Chair,
Or he could withdraw it.
May I?
obviously.
Yes,
Chair?
Commissioner Jacob?
I am trying to understand Commissioner Horowitz's comments on the friendly amendment, and in particular, the chilling effect aspects. May I ask Commissioner Horowitz to explain how giving a recipient of an opinion the comfort of knowing that staff will not recommend against what it had previously advised is a negative to this process? I just want to understand it.
So I hear your inquiry, Commissioner. However, at this point, Commissioner Yates has moved the motion and has rejected the friendly amendment. So to the extent that you want to have, discourse with Commissioner Horowitz about his opinion on the proposed friendly amendment, we can certainly take that up at another time. But right now, where we are is the resolution that is currently in your board book.
That's fair.
Is there any additional discussion? Okay, so for just to make sure that we're all on the same page, right now we have the resolution as currently in your board books. There is a motion and a second. There seems to be no additional discussion. So all in favor, please raise your hands.
This is on the amendment.
This is not on the amendment. We're back to the original resolution.
Oh, I thought Martin said you had to vote on the amendment first.
No, it was, since you rejected it, it's been considered, it's dead in the water at this
The
point.
main motion, then fine.
Okay, please raise your hands if you're voting yes. I see Chair Varlak, Judge Yates, Commissioners Fisher, Weissman, and Deering, Judge Braun, Commissioner Horowitz, McNamara, and Judge Newton. I'll call the remainder of the roll. Commissioner Cohen.
Yes.
Commissioner DePiero.
Yes.
Horowitz, Fisher. Commissioner Jacob.
No.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Motion carries, ma'am, 13-1.
Thank you. Moving on to item 5 on the agenda, it is a proposal from the Confidentiality and Records Access Committee. Behind Exhibit E, you will find.
May I interrupt, Madam Chair?
I would ask that you.
May I interrupt? We didn't have
Continue.
a vote on Commissioner Jacobs' amendment.
Yeah.
Can you hear me?
I can hear you.
Does Commissioner Jacob wish to propose the amendment? If he does,
Commissioner
I'll
Jacob?
second it.
I do. I wish to propose the amendment.
Please continue.
I thought that's what we were going to do after the vote on the resolution.
You are exactly right. That is my mistake.
The amendment seconded, Madam Chair.
Thank you. So we need to understand exactly what the language would be. So if you can please walk us through your proposed amended language.
Well, I'll try to put it as felicitously as possible, and I apologize for not putting it in writing before. But the amendment, it's a motion to, I'm just trying to collect my thoughts. It's a motion to give comfort to persons who seek and receive advisory and advisory opinion of staff to not be proceeded against by staff if all facts are presented in the request and are followed, and the opinion is followed, provided, however, that it is not a bar to the commission itself.
Okay. Thank you.
And
Are there...
I just to state why I propose this, it's that the regulated community should have such comfort. It should know that when it seeks advice and it receives it, that advice, if followed, will not end up in an enforcement proceeding. I think it's a fair way to proceed, and just to allow the presentation of the opinion in a proceeding, I suppose a recipient can always seek to introduce an opinion in a criminal or civil litigation. There's not anything we're providing except to say that, we could stop you, which would be silly. So just permitting someone to present such in defense at any criminal or civil action is an offer of nothing, I would say. Now, the statute, section 16, in the formal opinion context, is a mandate by the legislature that the opinion of the commission itself, a formal opinion that is a valid defense in any criminal or civil litigation. But the legislature can mandate that on the courts. We cannot, nor can staff mandate that the opinion is a defense, a valid defense. So all we are doing is saying to the recipient, well, since we can't mandate it, we'll allow you to present it. Well, that's a right the recipient would have in any event, so it seems to be quite empty. But when you tell a recipient, you have the comfort now of knowing, since you have followed everything in the opinion, you've given the staff all of the facts, the staff will not turn on you and recommend enforcement against you. Now, that's comfort, and that's what a recipient deserves, and that's how the process, in my view, should work. So I'm trying to put some teeth into this. It is not in derogation of anything in this resolution. And that's why I said earlier, I'd like to hear a little more from Commissioner Hurwood.
Thank you.
Happy to do that, Commissioner Jacob. For many years, I've heard from you and a number of other commissioners that it's not the staff that makes decisions about enforcement actions. It's we who make the enforcement actions. And when I say that your amendment gives cold comfort to those who are going to call the staff and ask for opinions, it's in that little last phrase that you mentioned that I heard you say that the safe harbor would apply to recommendations that the staff made, but in no way did I hear you say that there's safe harbor for the employee who seeks advice from us, the commissioners. And since we're the ones that make decisions about enforcement actions, and as you have said eloquently so many times over the years, that the staff does not have the authority to do that, That is what I mean when your amendment provides no comfort at all. And in fact, I think it will have a chilling effect, because anybody who actually understands that they can call up the staff and ask for an opinion and disclose all facts honestly, forthrightly, and comprehensively, but they don't get the comfort of knowing that a group of us can decide for whatever reason that we think an enforcement action should proceed. That is no safe harbor at all, Commissioner Jacob, and that is why I'm going to oppose your amendment.
Thank you. Thank you very much. Chair, may I respond to that?
Yes, Commissioner Jacob.
As you well know, such comfort is never preclusive of those who know nothing or little about staff actions. We are not following, we do not follow all of these letter opinions or know exactly what staff is doing. Staff is relying on precedent in giving them, and it is still comfort for those who receive it. And as you well know, if staff ever, or we on our own motion, wanted to sue, one of the major factors we would have to consider is the fact that our staff had given an advisory, and that if that were the fact, we wouldn't do very well in litigation, and you know that. You're a litigator. So you know if our staff gave such advice and we unilaterally instructed staff to institute enforcement, and the recipient of the letter introduced that advisory opinion, we'd probably lose the case on the equities for sure. But historically, no organization that uses no action letters has ever done what you're suggesting. So I think the comfort is not cold, it is very warm, and it's something the regulated community out there deserves to get, and we ought to provide it.
Thank you, Commissioner Jacob. Is there any further discussion? Yes, Commissioner Fisher. I think you're still muted. Well, I'm showing the.
Nope, they're on.
There we go.
Yeah, okay. Chair, I can well imagine supporting an amendment along the lines of what Commissioner Jacob suggests, but I don't know exactly what the language is that's being proposed, and I haven't had the benefit of hearing from our general counsel or other staff members. I haven't had the benefit of hearing from other commissioners, and in the past, there's been disagreement between commissioners that gets clarified by other commissioners, especially those of you who are attorneys, taking the time to review the language, talk to staff about how it would impact their daily work. And before I could support an amendment along these lines, I would want to receive the benefit of that information from staff and from other commissioners, so I clearly understand how this might impact the resolution that we just passed. So today I would say that I'm going to oppose this amendment, but I am open to supporting something along these lines in the future.
Thank you, Commissioner Fisher. Commissioner Weissman.
Thank you very much, Madam Chair. Well, Commissioner Fisher is a layman. As a lawyer, I'm hearing things and I'm not putting them totally together. And I think maybe other lawyers are thinking the same thing. I would request both Commissioner Jacob and Commissioner Levine to withdraw the motion and permit some language to be developed in consultation with our general counsel and shared with the commissioners, so we can all at least get on the same page as to what we're talking about.
Commissioner Jacob, are you amenable to that request?
Yeah, I can provide some language, but if the commission feels, the other commissioners feel that they'd like to proceed with this at another point where the staff can weigh in and others as well, I don't want to weigh this particular meeting down on language, staff comments, and I would agree to proceed and allow this to be developed at another time.
Thank you very much, Commissioner Jacob. Moving on to.
May I interrupt with a question, Madam Chair?
Is your question, Commissioner Levine, with respect to the withdrawal of Commissioner Jacob of his friendly amendment, of his motion?
The question is with respect to informal opinions already granted. Could I have staff or you apprise us, where did we leave off consideration of divulging, redacted if necessary, previous opinions rendered to statewide elected officials and department heads?
Yeah.
So,
General Counsel Stan.
So, Commissioner, the resolution 21-01, which was just approved by the commission, answers that question prospectively only, that going forward, the commission can publish informal letter opinions in redacted form. So the question that you're asking about prior letter opinions issued by staff has not been addressed by the commission. This is just prospective.
Okay, I'm going to keep us moving.
Madam Chair, if I may, at the May meeting, I'm going to propose an amendment to divulge the previously rendered opinions to the statewide electeds and department heads. In accord with how we've handled Commissioner Jacobs' amendment today, I would also ask that the proposed resolution in consultation with staff be developed and sent to the commissioners before the next meeting.
Understood, Commissioner Levine. Thank you. Item 5 on the agenda is a proposal from the Confidentiality and Records Access Committee. Behind Exhibit E, you will find proposed amended regulations for access to publicly available records. Relatedly, General Counsel Stam circulated last night on behalf of Commissioner Levine a proposed amendment to the revised records access regulations. And I believe if you have that document, the amended language is highlighted in yellow. So General Counsel Stam, I would ask again if you could just give a high-level summary of the version of the regs that are in the book, just so that we're all on the same page. I think that what we would do, as we previously did, is we would need a motion to adopt the regulations, and then we can move into discussion with respect to the amendment, the proposed amendment.
Exactly. So the committee, this is coming out of the work of the committee, these regulations in this revised form has been presented to the commission previously, but has not been acted upon by the commission. At this point, the commission could initiate a rulemaking proceeding on these regulations. So just so everyone's clear, 937 exists. We follow this right now. The committee is proposing the amendments. You can see them in the red line version behind tab E. Correct? Is it tab E? Tab E.
Yes.
And if the commission moves forward, it will start, we will then submit it to be published in the state register under the State Administrative Procedure Act, and there will be a 60-day notice public comment period, then we will determine whether or not to incorporate any of those comments, and the commission could then either continue a rulemaking or adopt the regulations at that point. As we talked about in the past, with one exception, the disclosures and changes to Part 37 relate to information about financial disclosure statements. At present, only the financial disclosure statement itself is available, but the new section 937.1B makes additional information relating to financial disclosure statements available. And then in addition, you'll see subsection C, which was a change suggested by Commissioner Weissman previously, which is to also make information relating to staff titles and salaries available under the records access regs. And these regs, so everyone understands, this is the process where members of the public seek documents by submitting a request to our records access officer, who's Walt McClure, and these are routinely documents that are just turned over as part of that process. As you know, we are not subject to the Freedom of Information Law. If anyone has more questions, I'm happy to answer them.
Thank you, General Counsel Stamp. So at this time, is there a motion to adopt the amended regulations?
May
I see Commissioner Horwitz.
Horwitz. Is there a second?
Just to be clear, Madam Chairman, this is to move the regs that came out of the proposal that came out of the work that we did on the committee, but it is not a motion with respect to the amendment that Commissioner Levine has proposed. Is that correct? I mean, that's what my intention. That's what my intention is.
Yes, that is correct. Thank you, Commissioner Horwitz. I see a second from Commissioner Fisher. Is there any discussion?
Yes.
Yes, Commissioner Yates.
I'm generally in favor of this. I'm on the subcommittee, but when we broke last at the end of the subcommittee meeting, I said that, and I asked Martin and Walter McClure, could you make clear that the information you're talking about here, when you use the term information, that you're only talking about expanding what can be divulged regarding FDSs, and that you're not in any way, by negative implication, saying that other information other than that can't be disclosed. And this goes to a general proposition, and that is that Executive Law 94-9A says that testimony received or any other information obtained by a commissioner shall not be disclosed during the pendency of a matter. There is a core question that we've had continuing for over a couple of years, and that is, if a commissioner obtains information.
Walt, do we know what that sound is?
I do not. Hold on. It looks like Commissioner Cohen. Okay. Commissioner Cohen, you'll have to unmute again when you are ready to come back on.
This goes to a core question, and that is, we receive some material during the course of an enforcement action, either giving advice or investigating. That clearly by statute is confidential, no question. There's other information that we receive during our deliberations, some of which go towards the structure and practices of the committee, some of which are either before or after the pendency of an action, etc. Other information, just general discussions sometimes when there's no investigation going on. That's information that we receive. And there's a split, I think, within our community here about whether that is confidential or not, especially if it's something that was discussed in an executive session, but even if it was something that was not discussed in an executive session. Some people, out of an abundance of caution, and I include myself in that group, never talk about anything, any information that we receive in the commission, because I don't want to trespass. But some people, and I think maybe rightly so, have pointed out that, hey, you know, you have discussions and you get information that's not related to an investigation, and you should be free to either talk to your principals or the public or other people about those items. There's nothing in the statute that clearly makes that kind of information confidential, but there is ambiguity in the language of 9A, which says that other information received by a member of the commission is confidential during the pendency of an action. So now I'm going back to the original motion here, and I'm sorry for belaboring this, but it's important. In the proposed amendment here in 937, it outlines certain information that may be disclosed that go beyond just public record access. It allows, for instance, Walter McClure or the chair or one of us to actually talk about an FDS, even though it's not part of a public record access request. I'm okay with that, and I support that amendment, that proposal, but I'm very concerned. I use the term negative implication. I'm very concerned that someone's going to turn around at some point and say, the only information that's not confidential under 9A is the information that's authorized by 937A. And if you have any other discussions about things that have occurred within the commission, even if it's unrelated to an investigation, that all of a sudden we're expanding secrecy, which is the last thing we want to do.
Chair, may I speak? Commissioner Jacob here.
I'm sorry. I was actually acknowledging General Counsel Stammen, and I was muted. I apologize. And then I will call on you, Commissioner Jacob. General Counsel Stammen, do you have a response to Judge Yates?
Sure. I understand what Commissioner Yates' concern is, but as I've explained before, these regs are the direction of the commission as to what documents staff is going to make publicly available through the process that's laid out here. It is merely, it used to just follow the statute, which was 9419, and only made those documents available through this process. And the process, while we are not subject to FOIL, the process provides how you request information from staff and how you get access to it, and a process for challenging determination by staff not to turn over a document. It doesn't, in and of itself, expand what is or is not confidential. It's just a declaration that what is in here can be made public by staff. So while I understand Commissioner Yates' concern, I don't think it goes any broader than that. But that's certainly not the intention. This is just to clarify what our public information officer can turn over at this point in time, once these regs become effective.
Thank you, General Counsel Stammen. Commissioner Jacob?
Yeah, I agree with the statements made by Commissioner Yates, but would add the following. This is a significant expansion of an existing reg that is being proposed. And the expansion goes into the area of information. It leaves the records area and creates a whole new area called information without any statutory predicate expressed in the proposal for regulating information. But even more problematic, what is information? There is no defined term in the statute that I'm aware of, and this reg doesn't define information. This is, we as a commission, we're proposing to regulate information. We know what's confidential because we have a half dozen statutes that deal with confidential information, but they are specific, like 9, like 13, 16, but to propose a reg that expands on a records provision, this is not an information reg. This is a records reg. It tracks 19A, which deals with records. and creates a whole new area, an undefined area called information, only promotes additional secrecy. And as you all know, we're already under severe criticism of being much too secretive. So I'm not for even proposing a reg until I see a memorandum of law from counsel that advises me about the statutory predicates for going forward with this kind of an undefined expansion of this reg.
Thank you, Commissioner Jacob. Judge Newton?
Yes, good morning, all. My question may sound very fundamental because it is. And I've been listening to this discussion and read the proposed change in regulation, but it's the use of an extraordinary power to create another regulation. So I'd like to ask Ms. Stamm and anyone else who can answer my question, coming as an outsider. You talked, Ms. Stamm, you used the words about what the intention of this change, these changes were. And so I asked the question more for someone who is coming at this for the first time, not only what is the intention, what is the need? What is the reason for this significant change in the regulation? And if you could say, I am a lawyer, 45 years, a judge, but I'm new to all of this, and I'd like to know the reason, if you could, in plain English, what is the evil or the problem that we seek to address by these significant changes?
I will ask General Counsel Stamm to respond.
Thank you.
Sure. So, Judge Newton, the committee undertook to see if there were ways in which the commission could be more transparent, make more records and information available. And this is just one of the various subjects that the committee undertook. And certainly the members of the committee could speak for themselves about what their goals and intentions were. But with respect to Part 937 specifically, so these regulations currently exist, and they adhere strictly to the statute. And only those documents were available through our records access regs, such as the financial disclosure statement itself, certain documents relating to investigations like settlement agreements or what are called substantial basis investigation reports, the final decision of the commission, lobbying records. And this is all spelled out in the statute and in the first part A of these regs. What the amendments propose to do is to make additional information about financial disclosure statements available, and they are very specific as to what information would be made available. So this is in response to requests for information that over the last 10 years, the commission staff have received, but we've had to respond, we do not have anything responsive because these things haven't been made publicly available. So if you wanted to find out the date on which someone submitted their FDS, that has never before been made publicly available. If you wanted to find out if someone was required to file an FDS, so in other words, you asked for an FDS and you were denied that document, you were never before able to find out whether or not that person was required to file, whether or not they were late in filing, whether or not they have an extension, whether or not they have an exemption from filing. So these are the types of information that would now be available. So if we receive a records access request for an FDS, or someone wanted to find out who is required to file at a particular agency, that information would now be available. We have documents and records reflecting this information, but it's a computerized system, which is very hard to make publicly available. So the best way to make it available would be just to supply the information itself. But I understand Commissioner Jacobs' concern, but that's the reason why the word information was used. And then the specific information is identified in Part B, in addition to the change that Commissioner Weissman previously had suggested, which is the information relating to staff salary and titles, which, since we're not subject to FOIL, has never before been publicly available through a request to JCOPE. But all other agencies who are subject to FOIL do have to make that information available. So Commissioner Weissman has suggested we add it to our regs as well.
And we want to do this solely on the issue of transparency. That people want to know, so we should let them know. Or is there some deeper concept that's applicable here?
I think it's really about transparency. I think you hit it right on the head. It's about people have a right to request, the members of the public have a right to request financial disclosure statements. And when they aren't able to be made available, they can now find out more information about why it's not available at this moment in time. And so this is the type of information that's included.
And this will apply to everyone who applies to, who has to file a non-disclosure statement, not just, say, elected officials or government heads. This is like the person at a certain grade who just happens to have a good salary. That person would be subject to these this information request as well. This broader information request as well.
Yes, so there's approximately 30,000 state employees and officers who file financial disclosure statements. And so at present, by law, their financial disclosure statements are publicly available, but this additional information is not. And so you're correct that this would be additional information for all 30,000 of those people.
Okay, so I've got 3 additional hands. In order, it will be Judge Braun, Commissioner Horowitz, and Judge Yates. Judge Braun?
Yes, as to what Commissioner Jacobs brought up, it is defined in the regulation with the proposed amendments. Section 937.3A says a request for information pursuant to this part, I emphasize pursuant to this part, and then one goes back to 937.1, in which the first part sets forth what certain information would, what the term information would include. And then the additional proposed amendments of B and C set forth additional information, which if approved as an amendment to the regulation, would further expand the definition of information. So it is defined.
Thank you, Judge Braun. Commissioner Horowitz?
Thank you, Madam Chair. As the proponent of the motion, I wanted to supplement what Monica explained to Judge Bing-Newton. We have struggled from the inception of the commission with the tension between the need to, in our regulatory and enforcement function, preserve the confidentiality of investigations, which is consistent with public policy behind all regulatory and investigatory agencies need to complete confidentiality, both to preserve the rights and reputations of those who are investigated in the event that there are no charges that result, and also to preserve the integrity of the investigation, on the one hand, with a need for the public to understand what we do. And so we, as the subcommittee, I think, worked pretty hard to come up with a way that we can incrementally improve what we say to the public about a variety of the things that we do. And we've struggled, even as Jim has mentioned, with how to sort of thread that needle. In respect to what Monica has said, this particular issue that Commissioner Jacobs has raised, I think we worked pretty hard to keep it confined and to come up with a proposal which maybe isn't perfect, because frankly, I am concerned about making any sort of changes with respect to what we've historically kept as confidential, and I think for good legal and policy reasons. But I think that, understanding the desire of the commissioners that I serve with and the need of the public, that we should try to put a proposal forward. So I think, while not perfect, this is something that tries to strike that balance and put us in a better position and put the public in a better position to know some things historically that we have not been able to share. So I wanted to at least explain myself why I've moved for this and why I wanted to participate in the subcommittee's work. And again, to thank the other members of the subcommittee for working on I think a pretty good compromise proposal. Thank you, Madam Chair.
Thank you. So Judge Bing-Newton, I'm just going to give you 2 minutes to respond to Commissioner Horowitz, and Judge Yates to have you as next.
I don't have a response. I have a question. You use, Commissioner Horowitz, thank you for that explanation. You used the phrase investigations in your process of your explaining this to me. But I wanted to be clear that we would give this information regarding these 30,000 employees, even if there is, only if there's an investigation or regardless. And I see Monica shaking her head. It would just be open, period.
It will be regardless, and to the extent that, I mentioned investigations, obviously our confidentiality provisions reach beyond simply investigations, but some of the same public policy reasons that underscore confidentiality versus disclosure for investigations are invested with decisions about other things that we do and other information like the FDS. But again, I think the overriding policy, if you're going to balance, can we tilt a little bit more in favor of disclosure while still preserving people's rights to privacy and the like? I think this is a compromise that we thought, could move the ball forward in each of those needs.
Thank you, and thank you for your excellent work to the entire subcommittee. Thank you.
Thank you.
Thank you. Judge Yates.
I think Dan basically articulated much of what I was going to say in response to Judge Newton's question, but I just wanted overall, Judge Newton, we've suffered over the years with a lot of misstatements and misapprehensions made publicly about our work. People say we're dragging our feet when it's because of a refusal of people to participate or because of a request by a prosecutor to that we defer. We've had people misstate what our opinions were, our decisions, or our advice. There's been it's been a constant problem for us that we can't respond even when there are inaccuracies, gross inaccuracies in describing what we're doing. So the overall purpose of the subcommittee, which was formed before you joined, but I can't speak for the chair, I would welcome you to, if you wanted to join it. The work of the subcommittee has been figuring out ways that we can open up things that are not actually required to be confidential by the literal language of the statute. And we've been picking apart different segments. Dan used the word incremental, and he's 100% right. This is one little small step. It's an area where the commission can respond when there's when someone asks for an explanation about what's going on with an FDS. That's a good thing. It's not the biggest problem we have, but it's an incremental change that's good. My only concern, and I'm not asking for an amendment to 937, but I do think there should be an accompanying statement by us that we all agree that by designating here in 937 that there's more information that's available, we are not saying by negative implication that that means that 94.9A's restriction on disclosing information is now expanded to anything that's not in 937. That's my only one fear, and we don't need to amend 937. Judge Braun pointed out that there is a definition in 937. I just want an accompanying statement. I want us all to agree and be clear, if we're going to vote on this, that it is not restricting any other kind of information unless it's prohibited by law.
Thank you, Judge Yates.
May I, Chair?
Yes, Commissioner Jacob.
I think Judge Yates and others have described the task well. There are enforcement matters we deal with. There are regulatory matters we deal with. There are governance matters we deal with. By and large, the confidentiality attaches to enforcement matters. Of course, opinions have the benefit of anonymity, and there's certain confidentiality there as well. But by and large, our enforcement proceedings, from beginning to end, the very beginning to the very end, these are all confidential. But what we have managed to do over the last 10 or 11 years is create confidentiality, as Judge Yates suggests, where there's no specific statute that says that the information is confidential. And I agree with those who have spoken before. Not everything, almost everything, I should say, in 937 is proposed on information. There's no statute that prescribes the release of this information. We are saying that we have conducted ourselves that way and we haven't released it. Well, that may be a problem with what we have done for years. We haven't been as transparent as we should have been. And where the law says no, we should not do it. Or where the law does not prohibit it, we should have been releasing this information. And like Judge Yates, I'm afraid that more is less. By agreeing that everything in this proposed 937 on information was correctly withheld in the past, and we need a proposed reg to now release it, well, how much more do we need to release by proposed regs, which, if there is no proposed reg, will be criticized or reprimanded because somebody will say that's confidential. So I asked in my initial statements for a memo. I'd like to know the statutory predicate for saying that this information that we're proposing to release is prohibited to release without a proposed reg, or else this proposed reg is unnecessary. We can just proceed and do what is correct and be more transparent. So I will vote against this because I see no statutory predicate for it. I've received no memo on it. Thank you.
Thank you. So at this time, I'm not seeing any additional, just checking, hands raised on this issue. I move the question. All in favor of the proposed amended regulations as they are currently in the book, please indicate so by raising your hands.
Thank you. I see Commissioners Fisher, Weissman, and Deering, Chair Varlak, Commissioner Horowitz, Judge Newton, Judge Braun. Thank you. I'll call the remaining roll. Commissioner Cohen. We'll come back. Commissioner DePiro.
Yes.
Commissioner Jacob.
No.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Commissioner McNamara.
Yes.
Thank you. Judge Newton, you responded. Commissioner Weissman. Judge Yates, I apologize if I missed your hand earlier.
No.
Thank you very much. The chair responded. And Commissioner Cohen, I'll come back one more time. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 11.
Walt, did you mute Rob? Did you mute Judge?
He's back. I think he had to sign back on.
I got disconnected. I apologize. I vote in favor.
Okay, I have 6, 7, 8, 9, 10, 11, 12. 12 for, 2 against. Motion carries.
Okay, thank you. Commissioner Levine, do you want to speak to your amendment?
Yes, thank you, Madam Chair. The motion in chief, as it were, which just passed, is a significant improvement, deficient in some ways, but nonetheless a enhancement with respect to public disclosure. However, as adopted, the records access policy still leaves the Joint Commission on Public Ethics as an outlier. in an anomalous situation. Under FOIL, which applies to most, if not all, other state agencies, the so-called FOIL log may be divulged. In other words, it will be divulged upon request, the information relating to who has actually made a FOIL request. Similarly, as we have discussed in previous meetings, the New York City Charter provides that the Conflict of Interest Board of the City of New York divulge this information. In fact, the city charter, as I understand it, requires that the filer actually be informed whether the filer requests the information or not. The amendment now before the commission does not go that far, but it would permit the filer to inquire as to who has actually made the inquiry to review the filer's financial disclosure statement. I want to point out also to the commissioners that I've had a discussion with our Deputy General Counsel. And I believe that I can state, and it's certainly my intent in propounding the amendment, that once the information is divulged to the filer, it's in the public domain. And the filer can share the information with anyone that he or she deems appropriate. I move the amendment.
Is there a second? I see Commissioner Weissman. Is there any discussion on the amendment? Yes, Commissioner Fisher. I think you're still muted.
You need to hit the mute button on the phone by you.
I did hit the
There
mute
you
button.
go.
You're on.
Well, he needs to mute.
So I'm generally supportive of this, but there's two reasons that I think we should consider whether to vote on it today. First of all, I believe that this was sent on Friday afternoon to the committee that I'm part of, which is the Confidentiality and Records Access Committee. But as far as I know, it wasn't distributed further to all the commissioners, and I don't believe all the commissioners have had an opportunity to review this. The second reason is I had spoken with Commissioner Levine yesterday about his proposed amendment and put forward a couple of ideas for perhaps amending his amended regulation. One had to do with making this apply only to future requests for information. I think it's fair when you make a request for information to know that this may be disclosed to others. And I also think that there should be some sort of notice given when we disclose this information about whistleblowers. A scenario would be, I'm in a state agency, I believe that maybe my boss is doing something untoward with respect to awarding contracts or something. I would like to look at his or her financial disclosure. I do that, the person in question asks about who's made a request, and they find out that I've made that request, and they retaliate against me. So I would like the person requesting the information about who requested my record to be told there are laws in place, and I don't know the specifics, that prevent retaliation against folks that have made a whistleblower complaint. And please keep that in mind when you request information about who is asking for your financial disclosure. So I would like to see this amendment developed further and distributed to all commissioners in advance of our next meeting so that we can hopefully move forward with it. But until that happens, I'm not prepared to support the amendment.
Okay, thank you. Is there any additional discussion with respect to the proposed? Yes, Commissioner Horowitz.
I am hopeful that perhaps the proponent of the motion will withdraw it for further discussion. But I do want to point out, though, that at its core, this amendment,
in my view, is truly antithetical to the changes that we just agreed to in our last series of changes, which we just made. And the reason I say that is because at its core, and I'm not persuaded at all that just because something that the city politicians in the city decided makes good sense for them is something that we should necessarily follow. But at its core, the way I understand Commissioner Lonvine's amendment is that when somebody makes a request for an FDS, whether that's a reporter, a law enforcement agency, a member of the public who has concerns, a whistleblower, as Bill is saying, that the public officials whose FDS is required is going to be tipped off that somebody is looking. And I just don't understand how what we would be doing is effectively protecting public officials over the public's right to access this information. And I think it's, as I said, it's antithetical to having a functioning agency that that where the public is entitled to get information in order to protect the people whose information is being sought. And so I am hopeful, perhaps, that if the proponent of the amendment withdraws it, perhaps there's a way that the committee could look at this, as we've done historically, and come up with something that on a consensus basis will work. But as it's currently articulated, I am very concerned about it and would vote against it.
Thank you, Commissioner Horowitz. Is there, so commissioners, again, if you are not currently speaking or have not been called upon, if you could just mute your line because I'm hearing a little bit of feedback. Judge Braun and then General Counsel Stan.
I agree with Commissioner Horowitz. There is that concern, and there's an essential difference here. We just approved an amendment to the regulation which increases transparency in government, something I strongly believe in. But this is not transparency in government. This is the person asking for the transparency or following the expansion of transparency. The person who's asking for the information. And I do share the concerns that Commissioner Horowitz just expressed. I haven't finally made up my mind, my decision, though I'm certainly, for that reason or those reasons, leaning against voting for this amendment. I haven't seen what was apparently distributed to some, so I also agree that I would hope that the amendment will be withdrawn to be resubmitted before us in the future once we all have the opportunity to see the specific amendment that's been apparently given to some commissions but not all, and then revisit at that point.
So Commissioner Braun, just for your clarification, it did go out last night to all commissioners. You may have missed the email, but it was sent to everyone. Is that correct, General Counsel Stan?
Yes, I sent an email out. Sorry, there's definitely feedback. Sorry about that, but I sent an email out to all commissioners yesterday at 5:25 p.m. And I didn't get any bounce back. So I apologize if commissioners didn't receive it.
I think
I also just wanted.
I'm going to look now. We all get many emails every day, which I keep up with, but I'm going to see if I received this one. If it didn't bounce back, presumably I did, but I haven't read it.
Okay, Judge Newton.
Yes, Commissioner Levine, I also joined the group of people who ask you to withdraw and let us look at this a little bit more. I also read this first thing this morning. Rick, this is why I created a separate account just for Jacob, so I could keep up with the mini email. I first applaud you, Commissioner, on taking the initiative to write it and highlight it. It made it easy to recognize for me that there's an issue. And I look at it a little bit differently. I look at the 30,000 people who file these reports. I'll be very candid. My view is if somebody's asking to see my disclosure form, I want to know who that is, just as why, who and why. And that may be an immature way of looking at this important issue, but it is a visceral response that says to me this concern is a real concern, and it should not just be about public officials, but everyone, and things like this can be abused. So I would like to hear more, Commissioner Levan, and maybe council can, and others in the committee can advise us more of what would be the consequences of consideration of your amendment. And I'm on the fence right now because I just don't know enough. Thank you.
Thank you. Commissioner Levine, are you willing to withdraw the motion and postpone so that we can proceed, as many commissioners have requested, to have an opportunity? At least one commissioner hasn't seen it yet, but it would give everyone an opportunity to review it again and to ask additional questions so they're prepared to vote.
Well, first, Madam Chair, I want to thank the judge for the compliment. However, it is undeserved. The drafting was done by our staff. With respect to the substantive consideration of further deliberation, I certainly want to accommodate the other commissioners, particularly if there's been insufficient time to digest the material. In putting it aside for further consideration, however, Madam Chair, I do have another resolution on this subject that I would like to move at this juncture.
Is this a resolution, Commissioner Levine, that relates to the just approved amended regulations?
Yes.
Please continue.
We have addressed the subject before of whether the Executive Chamber or the Office of Inspector General have requested to review the financial disclosure statements of any member of the Commission. I believe it is the staff's position that they will not divulge this information without a vote of the Commission. I therefore move that the staff be directed to divulge to the Commission, without specific names, whether the Executive Chamber or the Office of Inspector General have asked to review the financial disclosure statement of any commissioner. And I would note, Madam Chair, there is obviously no question with respect to whistleblower consideration or retaliation associated with this motion.
There is a motion on the floor. Is there a second?
I second.
Thank you, Commissioner Weissman. Is there any additional discussion?
May I be heard?
Yes.
I think that's Commissioner
Hello?
Jacob. Go ahead.
I thought I seconded that motion, and
That's good. He can do it.
Commissioner Weissman did as well. That's fine. But this is what I was talking about with regard to 937. I think you focus upon the information that the amendment deals with. The amendment talks about disclosing to the filer whether or who has requested the filer's FDS. Now, I've searched the law. I see nothing in the statute that prohibits release of that information to a filer. And we have proceeded for a long time on the assumption that that is prohibited, despite the fact that other agencies around this state release that information routinely. But we have adopted a practice that is less transparent, more secretive, and now we need an amendment to a proposed reg to open up the information. And that is what I meant earlier when I said more is less. As we keep acquiescing in the notion that what has been withheld in the past or restricted in the past was validly done, and that we need regulations to open up the information, that is not helpful because we may miss something. And whenever we miss something, you can't be all-encompassing. The information we miss is being withheld. Again, all this discussion about information and what is confidential and what isn't, I've yet to see a memorandum from counsel that explains why certain information has been restricted, withheld for so long, unless that memo shows me a statutory predicate and points merely to what we've done for a number of years. I will continue to vote against these regulations.
Thank you. Is there any additional discussion? Commissioner Horowitz.
I don't intend to support this, but I don't understand why this is limited just to the executive chamber or the inspector general. What about the legislature? What about people that are hired by the legislature? What about the press? What about law enforcement? I mean, to Marvin's point, you know, I drawing this out, like, what, you know, there's a never-ending list of entities and individuals who could be interested for a variety of reasons in getting this. So I'm not supporting this, but you know, what about the legislature? What about the press? What about law enforcement? Why not just say, hey, we're the commissioners. We'd like to know who's looking at us. Anybody who's ever asked for an FDS, ever, for any commissioner, either currently serving or who's ever served, why don't we just ask for that? I mean, really, this truly stands things on its head. I mean, and to me, it smacks of paranoia and cynicism. Thank you.
Thank you, Commissioner Horowitz. Is there any further discussion? Okay. Martin, remind me, where are we? Or we have
there's a motion and a second to require staff to disclose certain information.
Okay. All in favor?
I see Commissioner Weissman and Commissioner McNamara. Commissioner Braun.
For the reasons stated by Commissioner Horowitz, I am against. It's too limited.
Okay, Commissioner Cohen.
No.
Thank you. Commissioner Deering. We'll come back. I think you all are muted.
Commissioner Deering, you're muted. You guys will have to unmute, please.
No. And well, just there seems to be an issue with regard to our muting and unmuting. We're unmuted at times, but can't be heard.
I think it's the second speaker that's using it.
Yeah, maybe they're the speaker. I don't know, but if you mute the speaker phone in front of you, that should suffice.
Okay, it doesn't. I vote no.
Thank you. Commissioner DePiero.
No.
Commissioner Fisher.
No.
Commissioner Horowitz.
No.
Commissioner Jacob.
Yes.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Have that McNamara. Judge Newton.
No.
Thank you. Commissioner Weissman.
You seconded it.
Oh, yeah, thank you. Apologies. Judge Yates,
Yes.
thank you. And Chair Varlack.
No.
1, 2, 3, 4, 5, 6 in favor, 8 against. Motion fails.
Thank you. At this time, may I please have a motion to move into executive session pursuant to executive
If I
law
may,
section?
Madam Chair, under
If you
other
could just,
business.
if I'm
So
literally-
moved.
Madam
Motion.
Chair,
Motion.
Madam Chair, Madam Chair.
Yes, Commissioner
I
Levine.
believe there is on the agenda other business in the open session. I have other business.
I am looking here. The next item on the agenda is moving into executive session. So at this time, I am asking for a motion to move into executive session pursuant to
Madam
executive
Chair, if
law.
I may,
Please
Madam
don't.
Chair, if I
go
may,
over-
on a
I move.
point of order, doesn't
Thank
the
you,
agenda provide
Commissioner
for
Horowitz.
discussion of other business in the
It
open
does.
session?
After executive session, Commissioner Levine, I would invite you to take a look at the agenda. Thank you, Commissioner Horowitz. May
Well, I
a
have
second?
other business. Are you saying that I cannot proceed with other business in the public session?
I am saying that we will proceed to that when we get to that item on the agenda. We have a motion and we have a second to move into executive session. All in favor?
Well, do I understand correctly, Madam Chair, that you will not permit me to address any other subject in the open session?
Commissioner Levine, I don't know what it is that you want to address. However, I am saying that I am following the agenda that we all have, which indicates that at this time, we are moving into executive session. When we come out of
But
executive
it's
session.
been the practice, Madam Chair, in the past.
Please do not interrupt me.
You interrupted me.
I actually was speaking and you've interrupted me several times. So we are moving into executive session because that is in fact the next item on the agenda. As you are aware, we have a great deal of work to do. When we come out of executive session, there is an opportunity to discuss new and other business. We have a motion that has been seconded and I am now calling for the vote. All in favor to move into
On the
executive
point of
session.
order, do I understand it's the ruling of the chair that henceforth no other comments or business will be permitted by a commissioner in the open session without the approval of the chair? Is that your ruling?
I did not say that. I was very clear with what I did say.
But
We are
isn't
in the
that the
process of-
practical implication of what you just stated, Madam Chair?
Commissioner Levine, you're out of order. We are in the middle of taking a vote. All in favor of moving
Wait.
into executive session? Please
May I
raise your
speak on the motion before? Is there any discussion on the motion?
Go ahead, Judge Yates.
Thank you. I think just in fairness to Commissioner Levine, if there's going to be a change in the way we've always practiced so that it's out of the expected sequence, that should have been a commission decision, not something that was done in an agenda that was sent to us without fair warning. I really don't. I think Commissioner Levine expected to go that we'd have the regular practice and order here, and that's why I'm going to vote no on this motion.
Understood. Is there any other discussion?
Yes,
Commissioner Fisher.
Commissioner Jacob, please.
One moment. Commissioner Fisher has been acknowledged.
Thank you, baby.
Commissioner Fisher, you're muted. You're muted.
Someone unmute me.
We can hear you now.
Okay, thank you. I plan to support this motion. I feel it's perfectly reasonable to get into executive session. We have a number of things to discuss. We had a special meeting just because there were so many things to discuss. I think that the agenda clearly set forth and the agenda was distributed to us. I received it by overnight courier on Thursday or Friday. I had every opportunity to ask for a change in the agenda. I didn't, nor did any other commissioner. We've already heard from the chair that when we come out of executive session, we will resume the public session, and there will be an opportunity to introduce new and other business. And I will strongly support going into executive session now, given that we plan to have an open session with agenda item 7 being new and other business. Thank you.
Is there
Madam
any
Chair?
additional discussion? Yes.
Commissioner Jacob. Madam Chair,
Thank you, Commissioner.
on the motion, we have repeatedly relied on how this commission has operated for 10 or 11 years. And as a person who's been here since this commission's inception, I have never seen a meeting conducted in the way you are doing it. And I'm offended. There is a motion to shut us down. We are trying to have a conversation in public session and not back end what Commissioner Levine has to say to a discussion after an executive session. Now, I've been here, as I say, a long time. Some others have been too, although very few. But you may not be aware of this precedent, Chair Varlack, but we have never done this before, and this should not be the start of it, no matter what is on this agenda that was unilaterally prepared by staff in conjunction with the chair, et cetera. So I'm going to oppose any motion to go into executive session.
Commissioner Horowitz.
I've been here as long as Commissioner Jacob, and if I understand what he's saying, just because we don't like,
you were gone for a while.
Right. Well, in any event, I've been here for a while, and if I understand what you're saying,
That's different.
gee, I don't like peas, so now they want us to eat peas, so I don't like it. The fact is Bill's right. This agenda was sent out last week. Anybody could comment on it, number one. Number two, we're not shutting anybody down. You guys want to talk about something? It's just the chair's prerogative that we're going to do it afterwards. And frankly, the last several months, we have not been able to do the work that needs to be done. In fact, we had to have a special meeting, which you've only had one other time in our 10 years of history. And frankly, the need to have regular order, which is something I asked for several months ago, can we please proceed with regular order? You know, we're all committed, and I appreciate everybody's commitment to working on JCO, but frankly, some of us have other things we need to do. We have professional lives. And that's why regular order, in addition to all the other reasons to have good order in our meetings, we should follow that good regular order. But I'm obviously going to vote for this, and we've got a big book. We've had a big book. The book keeps getting bigger. We've got things to do. Gary, you'll have your chance. If I hear what the chairwoman is saying, you'll have your chance to raise what you're going to raise. It'll just be, let's get to the work that we haven't been able to do for the last 3 months. Thank you.
So I would just like to make something very clear. I am not at all trying to shut down discussion. The opportunity for commissioners to bring up new and other business remains on the agenda. That being said, as has been noted, this is an exceptionally, I understand perhaps it's the biggest book we've ever had. We have business to conduct, and that is absolutely our responsibility. I am calling for the question. All in favor of moving into executive session, please raise your hand.
I see Chair Varlack, Commissioner Fisher, Commissioner Deering, Commissioner Horowitz, Judge Newton, and Judge Braun. Thank you. Commissioner Cohen?
Yes.
Commissioner DePiero?
Yes.
Commissioner Horowitz, Commissioner Jacob?
No.
Commissioner Levine?
No.
Judge McCarthy?
No.
Commissioner McNamara?
No.
Thank you. Judge Newton, you voted, I believe. Judge Newton, did I see your hand? Thank you very much. Commissioner Weissman? Thank you. I see the thumb. Judge Yates?
No.
Thank you. And Chair Barlack, I saw 1, 2, 3, 4, 5, 6, 7, 8. Motion carries. We go to exec.
Thank you. Walt, please let us know when we're in executive session.
Stand by.
Thank you. We are now back in public session. General Counsel Stam, I would ask you to report on the activities taken during executive session.
The commission approved 2 requests to engage in outside activities under its regulations 19 NYCRR Part 932. The commission authorized steps in several investigative matters, closed 2 matters, and discussed several other investigative matters. That's the end of the report.
Thank you. We are now on to the new and other business portion of the agenda. Is there any new or other business?
Madam Chair, do I understand correctly that the meeting must end at 3:30?
We will no longer have the technological support that we need to continue the meeting past 3:30 today.
Do I understand from the discussion in the opening public session that in meetings to ensue, no statement or resolution will be permitted in the opening public session except as approved by the chair?
Did somebody make that representation?
I'm asking if that is your position.
I never said that.
I'm asking, is that your position?
I have never said that that was my position. It is not my position.
Well, what is your position with respect to the opening public session?
With respect to is there a motion? What is the point of this conversation?
Well, I want to understand for ensuing meetings whether a commissioner will be permitted to make a statement or offer a motion.
This meeting is being recorded.
Session before the executive session is conducted.
I'm sorry. I need you to repeat that. I lost a moment of what you said.
Yes, I will repeat.
Thank you.
The question is, with respect to meetings to ensue of the commission, will statements by commissioners or motions made by commissioners be precluded from the opening session unless prior approval is granted by the chair to conduct those discussions in the opening session?
Future meetings of the commission will be conducted in accordance with the agenda that is presented to commissioners in advance of the meeting.
Right, and it's the position of the chair that the chair has the sole prerogative to determine the agenda of the opening public session.
The chair puts together the agenda and makes sure that the materials are together, and it is sent out to commissioners, as you know, Commissioner Levine, well in advance of the meeting. If anyone at any time has a concern, they can certainly raise it.
I understand that proposition, Madam Chair, but my very specific question is it the ruling of the chair that it is the sole prerogative of the chair to determine the agenda for the open or public session, I will characterize it, conducted prior to the executive session?
And what I've indicated, and I will restate, Commissioner Levine, and I'm not going to continue to go back and forth on this because I think my position is clear, is that there is an agenda that is sent out to the commissioners in advance of the meeting. If there are any questions or concerns, then we can address them. When we open the meeting, we have an opportunity to move things around on the agenda, as we have done multiple times in the past, whether public session or an executive session. Judge Braun?
As per meetings I've gone to in the past, and my understanding of Robert's rules, which I understand we don't necessarily follow, but do it to some degree. The chair runs the meeting. The agenda is put before the body. We can always, as the chair just said, we, the commissioners, the body, in this instance, can move to amend the agenda and change things. Old business, otherwise in our agenda called other business, is generally under Robert's rules the next to last item on the agenda, the new business being the last item. I understand, being new to the commission, just having joined the end of January, that there's some tradition of taking old or other business and new business before going into executive session, but it doesn't necessarily have to be done that way. So if the agenda was set in a certain way, was modified today, the body, we could have moved and voted to change the agenda before we went into executive session, but we had a very busy agenda today. And my understanding for what the chair said was that was the reason we went into executive session before taking up new and other business. Today or next, we could have, or next time, or any time, if we want to, somebody could make a motion and we can vote on that to change the order of the agenda. So I don't think anybody's precluded from speaking or raising items, no matter how the agenda is set up.
Thank you, Judge Bowman.
Thank you, Your Honor. May I, on the follow-on, Madam Chair, point out that if today is an exemplar, a very serious question is raised about this unprecedented procedure which you have instituted. The post-executive session, open session, has been limited to approximately 10 minutes.
So I'm not sure if there's a question there, but what I will say
It's a statement.
is that
You have unilaterally departed from the precedent that was established early on in this commission and has been our practice until today. And I find it objectionable.
What is that departure? I'm sorry?
The departure is that by the machination of moving other business to the post-executive session portion of the meeting, it necessarily time limits in an unreasonable manner any discussion that the chair does not choose to have in the open session.
Yeah,
That's objectionable.
I would object to your characterization here. The fact of the matter is, Commissioner Levine, is that a part of the reason that we have as heavy a book as we have in this particular meeting is because you have gone on at length in previous meetings about topics that you wish to discuss. It is my responsibility to make sure that we address the items that need to be voted on before the commission. My work here was to make sure that we addressed the work that needed to be done. And I think, in fact, that we did a very good job. If you want this meeting to continue until 5 p.m. today, so that you can have the opportunity to say anything it is that you would like to say, I would not have objected to that. This limitation of time is not mine.
Thank
you very much,
ma'am. Meeting to end at 3:30.
Yeah, may I, before we get cut off, Commissioner Jacob here, may I just say, and I haven't got the law in front of me, but I look at the executive law, which doesn't speak about who sets the agenda, who writes it, who controls it. In the past, our chairs have been rather passive and have allowed discussion to proceed, and we've done it quite successfully. But the chair is one vote, the same as we all have, but has one privilege above all of us. The chair may call a meeting, but the statute does not say that the chair not only calls the meeting, but sets the agenda so that we cannot continue to do what we've done here for 10 years. So I I've got to disagree with you, Madam Chair, but I'm looking at the law, and I'm looking at our process, our procedure, and our tradition, how we've operated here. And you've come on rather recently, and I understand what Commissioner Levine is saying. And I think we've got to cope with this, and we've got to have a good answer, because he's asking a very good question. Good questions deserve good answers.
What is the question?
Look, I don't want to go.
I have not made any unilateral decisions. As I said, the agenda was circulated in advance of the meeting.
No, but the question, Madam Chair, the question is, had we seen the agenda and focused on the intent of the agenda? Because I was taken by surprise. The agenda didn't have an item in it. I never looked for the presence of the item because I never assumed that this meeting would be conducted in any way other than all the rest of them.
I'm sorry, what's the missing item, Commissioner? What is the missing item?
You took the position that there was no new and other business on the public session agenda.
No, that item is on the agenda. It is on the agenda.
It was on the agenda, but you took the position that you could move that item, whether it's on, off, whatever. I didn't make any such assumption when I read that agenda. I had no knowledge of whether I should call anybody, including yourself, and ask. But now I know. And now Commissioner Levine knows. But why can't we agree to conduct our meetings as we have always conducted them? Why do we have to get into these disputes at this late stage?
I have a question, Madam Chair. If we can conduct the business of the commission in an efficient way, as we have today, why do we have to succumb to what we've always done? That suggests new people like me on the condition are lesser commissioners, and I resent that notion. This is a discussion I've heard of this commission and looking at some of the past concerns. Super commissioners, older commissioners. I think that we need to focus on doing the work of the commission in an efficient manner. So we now know that Madam Chair is going to send us the commission agenda. Somebody has to do it. We now know that every commissioner has an opportunity to make suggestions to her. We now know after today, we as a commission can vote, which we did, and we voted majority to go into executive session. So there's a lot for all of us to consider. And I agree there should not be any acrimony or anger, but I think that we should focus on this, and that is how can we're very concerned about what other people think of JCO. Why can we, in that effort, it's my opinion, have a meeting that's done efficiently and carefully and get some of the old business done? Thank you, Madam Chair.
Thank you.
With all respect, I thought that was directed at my comment. May I just respond? With all respect.
Let me assure you, I was not directing it at any single person, Commissioner. I was talking as the junior commissioner about my observance, having been on the commission for last month, and I am not, everybody else gets to say what they want to say, and that's to the whole commission. Well, thank you very much, sir.
That's fine, but I have 10 years of hard work invested in this commission, and so have a few others. 10 years. You just got here, and that's not a statement to say that you are in any way inferior to me. But when I raise the issue of may we continue as we have continued before, I'm not denying you the right to raise new issues. Of course not. But don't deny me to take the position that I have some expectation, which is justified, that we continue as before. And all this business about precedent, when you talk about the informal letter opinions, we're constantly told about, oh, it was done that way at COPE, it was done that way at the state, at the commission prior to COPE, it was done that way for 10 years. But when it comes to process, and that's law, when it comes to process, all of a sudden, all precedent has no meaning. We could just recreate, do all these new things. I'm trying to explain my position. I am certainly not declaring that certain commissioners stand at a higher level than others. But I shouldn't be faulted because I've been here a while and have become accustomed and expect a certain way of how this commission is conducted in public session. Public expects to hear from us. And all of a sudden it doesn't hear from us. That's why we have this great reputation, as you know.
Chair, if I could make a couple of comments.
I'm sorry, who's speaking?
Commissioner Deering.
Yes, Commissioner Deering.
I'm just wondering if this is getting blown out of proportion. We had a significant agenda today. It is up to in any entity, the chair works to put together the agenda. We had a lot of work to do today. This item wasn't taken off the agenda. It was just reordered. And today we had the circumstance where we had to end by a certain time. I think that was known to everybody. People could have used their time accordingly. And at the end of the session, instead we used this time to start arguing about this, which, quite frankly, to me is a lot about nothing. So thank you.
Thank you, Commissioner Deering. Does anybody else have any comment or any other new or other business?
May I ask? It's now 3:36. I thought the meeting technically had to end at 3:30.
That is the case, but I understand that the medical appointment that needed to be attended has now been canceled to accommodate our continued discussion. Is there any other new or other business?
Yes, I have a motion with respect to the agenda for the May meeting. I move that a further discussion about Executive Order 202.7 be discussed in the public session prior to the executive session in May, as I would have done today.
There is a motion on the table. Is there a second?
I second that.
Was that Commissioner Jacob or?
It was.
Thank you. Is there any discussion?
Do we have a quorum to vote on any motions now?
We'll find out when the vote takes place.
We have a quorum.
Because I, for one, will need to leave, but I'm still here.
Thank you, Judge Braun. Is there any discussion on the motion? Okay, all in favor?
I see Commissioner Weissman, Judge Yates, and Judge Braun. I'll call the remaining roll. Commissioner Deering? Sorry, Commissioner.
No.
Thank you. Commissioner DePiero, Commissioner Fisher?
No.
Thank you. Commissioner Jacob?
Yes.
Commissioner Levine?
Yes.
Judge McCarthy?
Yes.
Judge Newton?
No.
Commissioner Weissman doesn't seem to be there. Commissioner Yates?
Yes.
Thank you. And Chair Varlack.
No.
I'll go back. Is Commissioner Weissman still present?
He voted yes. He
Okay.
left.
I must have missed
Commissioner
that.
Fisher, can you confirm?
Can you put that up? Yes, we can confirm. Commissioner Weissman voted yes before he departed.
1, 2, 3, 4, 5, 6 in favor. Motion fails.
Is there any other new or other business? Can I have a motion to adjourn the meeting?
I'll move. Deering.
Thank you.
Seconded.
Second.
Fisher.
All in favor?
Varlack, Deering, Fisher, Newton, Braun, Judge Yates, I assume. Was
No.
No. Okay, thank you for clarifying. Deering, Fisher, it's Jacob.
Yes.
Levine,
Yes.
McCarthy,
Yes.
Newton.
She voted, I think, yes. So
I
just the
voted
chair?
before, yes. This is to adjourn the meeting, yes.
Yes, ma'am. Weissman is gone. Yates, you said is a no, and Chair Varlack.
Yes.
1, 2, 3, 4, 5, 6, 7, 8. Motion carries.
Thank you. Take care.
Everybody have a
See you
good
next
day.
time.